So hello everyone, and welcome to our week 6 colloquy on chapter 10, which we will be recording here in Springfield. So we covered chapter 9 earlier this week in Tumba, where we talked about chapter 9, and we talked about the intention to create legal relationships. Now remember, and this is also in your handout, so this handout again is the only handout really that you will need for contracts. In the handout on page 1, you'll find that I refer to element 1. Element 1, we said, is the existence of a contract, especially a simple contract. And we said a simple contract is one where you require to have consideration. And we said for that you'll have 3 sub-elements, all on page 1. The first is an agreement to contract. And as you can see there, I give you the law, and I give you an idea about application and conclusion. So I'm telling you what you need to put down for ILAC in the exam. So in the exam, if you find that the question is talking about a simple contract, you need to actually do what you see on page 1. So you'll start with the first sub-element. You don't have to put it all down. Of course, I don't want you to sit down and copy, or maybe some of you will even just attach this page to the answer. I don't need that. I want you to sit down and think which of this content is relevant to this question, to this scenario. Then you'll have to do the ILAC, so you take the law out of this, so just a few sentences, and you're on your way towards application and conclusion, and you're done. We'll do much more of this when we come to after the break and start preparing for the final exam. All right, let's get started then on chapter 10. So we said that this is the third element in relation to the existence of a simple contract. We said that you need agreement, and after agreement you need intention to create legal relationships, and the last thing is consideration. I will see how that there's also an exception called the theory of promissory estoppel, where you don't even need to have a consideration. But let's start from the top. What is meant by consideration? So consideration again is the price that you pay to buy the other person's promise. You know, we gave the example of selling maybe a pen to Bill here. I'm using Bill because Bill is right in front of me. So I will sell you a pen for $10. Okay? And Bill says, yes, I'll buy it for $10. So my promise is to give him the pen. He buys my promise with that $10, which is also his promise. And his promise to give me the $10, he buys that by my promise to give him the pen. So your promise is also your consideration. Sometimes your consideration is by conduct. So you don't promise anything, you simply say that I will do something. Like for example, the reward cases, where something is missing and you find it. We said fluffy, for example, and once you find it, that's your consideration. That's the price you are paying to buy the other person's promise of giving you the reward. Yes? So that's what we call bilateral contracts. You can go back and check it in chapter 7. So this is a bilateral contract, a unilateral contract, because it has only one promise rather than 2, and if it has 2, we call it bilateral contract. All right. Let's continue with what is, which consideration rather is present. When is consideration present? So we said that in order for you to have a simple contract, you need 3 things. You need agreement, you need intention to create a legal relationship, and you need consideration. Okay? So if it's a simple contract, you must have consideration. Okay? So it must not be passed, and it must move from the promisor. We'll go back and look at these examples, these cases, but let's just continue first with these simple summaries. Now, as we saw for agreement, we have rules for offers, we have rules for acceptance, and now we have rules for consideration. Okay? So the first rule says you must have a present consideration, okay, or a future one, but not past. Let's just look at an example. So I say to Bill, I want to give you this pen for $10, and Bill is going to accept it from me for $10. Because I'm saying I am going to, my consideration is future. I will. Okay? So I will give you the pen, and you will give me the $10. All of this is consideration for something to be done yet. So we call it future consideration. When is consideration present? That's when you have a fluffy situation. So there's a reward. I have already found fluffy, or whatever you are looking for. My now consideration is present. I've done what I have to do. Not past, it's present. Because what I did based on that promise you made to give me a $10 or a reward. Sometimes consideration is also past, which means that you have done something already, but you haven't done it based on the promise that was being made. For example, you found Fluffy, okay, and after you found Fluffy, you realized that, oh, this is actually my neighbor's cat, okay, and you took it to them, and they said, thank you very much, and then you realized, you saw some ad somewhere, that they were actually offering $100 or $10 or whatever for it. You realize this after you have done what you have done. That's why it's past consideration. Past consideration is generally not good enough for a simple contract to exist unless we have something called a sandwich. Okay, and we'll talk about that in just a minute. It must move from the promisee. Okay, so my promise to Bill is to give him the pen. I'm the promisor, he's the promisee. He is now the guy who has to give me the consideration. The consideration has to move from the promisee to the promisor. His consideration is what? The $10. Okay? It must have some value. You can't say, I'm going to give you zero. You know, that's not consideration. It has to have some value. Okay? It doesn't have adequate value. We're not talking about economics here, but it has to have some value. And we'll see that also in one of the examples. So the court is not concerned with adequacy. It must move, rather, it must be more than the promise of an existing obligation. So whatever you are promising, the consideration, the price you're going to buy the promise with, has to be something over and above what you have to do, for example, from a legal duty. Okay? We'll talk about that as well in a minute. Those are the examples you have to look at. Must be possible to perform, so you have to be able to pay this price. Must be definite, so you know exactly what you are paying and for what. And it must be legal. You can't, for example, pay with something illegal. Must be referable to the other party's promise. So if I say I want to give Bill the pen, so he's saying I will give you $10, reference to what? To my promise, to give him the pen. We'll flesh that out in just a minute. The distinction, again, we just talked about it. What's the distinction between past, present, and future consideration? So we said what we call present is actually executed. So consideration involves an act being done in return for a promise, or it could be future. Consideration involves parties exchanging promises. So you can see, you can have present consideration only in unilateral contracts. Okay? You will have future consideration where the parties are exchanging promises, so it's a bilateral contract. And there's also past consideration, which involves the giving of a promise after an act had been performed. Okay? And is generally not enforceable because the act must be done in reliance on the promise. The last thing I want to talk about today is something called promissory estoppel. Okay? So estoppel means that you are being stopped, you're going to be prevented based on a promise you have made. So if I do something based on a promise, you know, and then you renege on that promise, I can take you to court and say, I want performance, okay, because I have suffered a detriment. So promissory estoppel will allow a promise to be enforced, even though there has not been a consideration, so you don't really have a simple contract. It operates when it would be inadequate, so it's something from equity, or unconscionable, so it's about fairness for the promisor not to be held to their promise, and it may be used as a defense, so this is what we call a shield, or as a sword, as we will see in Walton's stores. Okay, let's start talking about some of these examples. And as usual, this is a theory, so it has elements, and you can find the elements. I'm not going to go through all of them in detail, at least now. We'll come back to it later, today, which is what you will find on pages 275 and 76 of your textbook. All right. Let's then get started on these examples, and we'll start from page 263. All right. We'll start from 1842, a case called Roscola and Thomas. It says Roscola purchased a horse from Thomas for 30 pounds. Okay. After the sale was completed, Thomas promised Roscola that the horse was in good condition and not vicious. And in fact, the horse was in fact vicious. So let's see if we can annotate on here. The key point here is after the sale was completed. Okay? So let me just quickly see if we can come up with the diagram here. So we have R and we have T. R gave T what? 30 pounds. And Thomas gave Roscola what?
Horse.
The horse. Okay? This is what we say is the purchase. And the purchase is complete. Done? What is the promise flowing from R to T? It's the promise that I give you 30 pounds. And what is the promise from T to R? Is to give him the horse. This is a unilateral or bilateral contract. It's a bilateral contract because you have two promises. So R promising T the 30 pounds means that T is going to buy that promise by what? What is his consideration? T's consideration is the horse. T is buying the $30 promise by the horse, with the horse. I'll give you the horse, so I get the 30 pounds. Vice versa. T is promising R the horse. So R is buying this promise with what? With a consideration which is what? The 30 pounds. Why am I complicating things? Here's why. After the sale, what did T want? More. Or rather, R wanted T to promise Roscola that the horse was in good condition and not vicious. Yes? Is this a promise?
No.
It says promised. What do you mean no? What is that? It says promised. Don't do this to me in the exam. If it says promised, don't go and say, oh no, because it says promised. Agreed, it says agreed. Okay? Both, sold, what you are told, this is what happened. So, we don't argue about those things. You argue about facts. Is it a fact in front of you that Thomas promised Roscola? That's it. Don't go beyond that. You can infer, but that's different. All I want from you is just to see that there was another promise flowing again from T to R. This time, what is this promise? Good condition. Yeah? That the horse is in a good condition. You see it? So So this is the question here. What did R buy that promise with? What is his consideration? I will tell you that this pen is in a good condition. I've sold it already to you. So what did you pay for this promise? Why should I give you that promise? What's your consideration? That's what we're looking at here. Previous, there was those two promises. So each one of those promises acts as the other's consideration. Now you have one promise, but there's no consideration. So that promise is not good enough. You can't go and say, he promised me that the horse is in good condition. What did you pay for that promise? Can you argue differently? Yes. So what do I need? So someone says, because this purchase has been completed already, you can't do much. So what can I change in an exam question to make this consideration, to make this scenario, or to make the promise from T to R come with a consideration? What can you change?
Maybe the promise that the horse is in good condition and not vicious actually comes before the horse
Okay. So, if before you paid those 30 pounds, you asked for two promises, that you have the horse and that the horse is in good condition, and for both promises I'm going to pay you 30 pounds, that's fine. The court is not going to say, oh, this is not enough, you have to pay more, because now it's two promises. We don't care. All that we're caring about is that nothing done, nothing finalized until you got the promises, and in reliance on those promises, you gave them the 30 pounds. Okay? All right. Let's see what something else. So the issue was their consideration to support the promise that the horse was not vicious. And as you can see here, they said what? The seller's promise was not binding. It was made after the sale had been completed. Comment: a promise made after the contract has been concluded must be supported by new consideration or executed under a seal. So that thing here under seal means that you're going to move from a simple contract to a formal contract. And you know that a formal contract does not require a consideration. Reflection. Would the decision have been the same if the promise regarding the temperament of the horse had been made before the parties reach agreement? That's what we just discussed. Explain your answer. So yes, that would change the outcome, because now that consideration has a price which is basically the 30 pounds.
The previous one was that you have the protection that it was what it expects.
Yeah, so this actually a case from 1842. So today, and we'll talk about it more and more, we have legislative intervention to give you guarantees that yes, the horse is going to be fit for the purpose that you have bought it for, and that comes under what we call the ACL, or the Australian Consumer Law. Okay? More and more we'll start talking about the ACL, especially under validity. When we look at the four steps or four sub-elements that come to the analysis of the validity of a simple contract after we finish the existence. All right. Let's look at another case. So now we're looking at 1869 with Anderson and Glass. With Anderson and Glass. So it says, Glass promised an employee. Okay? So he's an employee. Don't go say he's not he's an employee. this employee was promised higher wages, not only for the future, but also for a past period, when he was being paid a lower rate agreed to by the parties. Glass later refused to honor his promise. Okay? So you're an employee, an employment contract, without having to put it up, drawing it, an employment contract, you are being promised a wage or a salary, and in return there's a job description or certain tasks that you have to perform. That's a contract. Simple contract. What is the variation here? Well, the employee, during the contract, was promised higher wages. But not only for the future, which would be reasonable, right? If I give you a promotion or I give you a merit increase or whatever you want to call it, that's fine. We're talking about what's going to happen in the future. But his boss also talked about the past. Okay? But in this case, he was being paid a lower rate agreed to by the parties. This was still something they agreed on. But now they want to change it. Okay? Of course, the question is there consideration? Was the promise to pay the increased wages given before or after they had to perform the work? Why is that important? Because if it's before, then that work becomes your consideration. You promised me to pay me more, I promise you to work more. No problem. If this work has been done already, then you promised me to do more. What am I buying your promise with? The higher wages for what? That's the question. So the promise to pay increased wages with respect to the work already done was not binding. Can you see that? It's done already. What did you buy it with? Okay? And they say it's not binding because it was past consideration. Clear? You are trying to figure out what did this employee pay for this promise by his boss to pay him more. You pay him more for what? There had to be consideration. Yes?
So you're saying that because he already performed that work earlier, therefore that's kind of not something he can use as like one of his bargaining tips for how to behave in the future?
Correct.
Okay.
And why is that? Why do you think we would stipulate for such a rule? Can you see the uncertainty that you can create by an employee who has done something and he keeps coming back to you and saying, can you pay me a bit more for what I did yesterday? Can I pay me more for what I did 100 years ago? So you can't do that, right? Once you have agreed on something, you need certainty to move on. But if it's something about the future, and I'm asking to do extra, then yes, we can negotiate and get a variation or a new contract. All right? Okay. Past consideration. They also said the work had already been performed and paid for. And as this was the only consideration that the employee could provide, his claim for the past period failed. The promise for future wages was enforceable because he could provide consideration there. So what they're saying is that the employee is entitled for the extra wages for what he will be doing, but he's not entitled for what he has done. What he has done was agreed on, even at a lower rate, but it has been agreed on with the employee. Promise is exchanged, and that's done. But if it's something that you still need to do in the future, that promise that the employer gave to the employee is a promise that's bought with this future extra work. All right. So, good illustration of the fact that as a general rule, past consideration is not good consideration. In the case of contracts of service, the difficulty, of course, can be overcome using the approach taken in the following case, which is Lampley and Braithwaite. So let's look at Lampley and Braithwaite, which is on page 264. Why would anyone want to go and look at a case from the 17th century? You still believe that, you know what they used to do in 1615? They used to hang people. What kind of society, do you still think that we have to go and learn?
Learn from our mistakes.
No, we're learning as a precedent.
But it's not a mistake.
We're taking,
contracts going on back then. Like the thing is that if you were an apprentice or something, you were working for money. So therefore, that's still an employment contract, right?
but I'm just wondering why you would still put something from 1615 in a textbook.
Because it looks prestigious.
I don't know. Let's look at the facts are very bizarre. A pardon and a king and stuff. Let's look. Braithwaite killed a man, and then sought Lampley's help to obtain a pardon for him from the king. So you can kill anyone and then go and ask for a pardon from the king or the queen now. I don't know.
You still do that.
Hopefully.
That's why it's still 1615 and we're still teaching it. Lampley had to travel to London. This is the guy who's going to get him the pardon. Okay? And as a result, incurred expenses. Okay? As a result, incurred expenses. So this is Lampley. Pardon obtained. Okay? After the pardon obtained, can you see the problem already? After. Braithwaite promised to pay Lampley £100. Back then that was a huge sum. But eventually did not honor his promise. So what do you see? You see those lines there? So you have Braithwaite, you have Lampley. Is there an exchange of promises? Braithwaite, yes?
Well, I think he doesn't actually make a statement like when he's saying, okay, yeah, I'll help you get a pardon. He doesn't sort of say, as long as you pay for any expenses.
Exactly.
Therefore, there's no exchange of promises. So he's kind of just doing it as a favor almost.
Okay. Let's see. So someone is saying there was no exchange of promises. Let's see. What did Braithwaite promise? What did Lampley do? Like Fluffy. What did Lampley do here? Sorry? Pardon. Yes? Lampley found Fluffy. It's the same, exactly the same. He got a pardon. He had to go to London and do stuff. He didn't promise anything, did he? He simply went and did it. He got the pardon. Braithwaite, what did Braithwaite do? He sought Lampley's help. Is that a promise? No? I lost Fluffy. Can you find Fluffy for me? I'm not telling you how much I'm going to pay you, but can you find it for me? Can you find her for me? So you go and find Fluffy. What do you think? A reasonable person is saying what? Why would I go find Fluffy if I didn't expect or understand what? When you ask me for help, of course, remember, these are not like friends. You know, this is not like, family, social sort of arrangement. This is someone who's a specialist. He went to the king and he was able to get the pardon.
Okay, so he's employed, so that's more sort of employment. He was employed for trying to go and get pardons for people and so forth.
Where's the employment?
Well, you said that he's a specialist, so and only a few special people can get pardons from the king. Obviously, it's not like everybody can wander into the king's palace and say, hey.
No, maybe I'm wrong. Maybe I'm wrong. Maybe he is not a specialist. Maybe he simply went to London, because we don't know on the facts. He simply went to London, and there he was able to meet a specialist and engage that specialist services.
Being a specialist is just an assumption.
Yeah, that's just the thing with you.
Yeah.
The thing is that
If I make that,
if
yeah.
Lampley went and saw a specialist who could get the pardon, that still means that Braithwaite wouldn't be promised to pay him anything, essentially, because there was no agreed on amount of money for.
Yes, but a reasonable person, would they do any of this? Without any. So why would you incur expenses? This is my point. As a reasonable person, why would you do that? Why would you go and get these expenses? And remember, the promise here was so after the pardon, the guy said, "I'm going to pay you £100." That's a huge sum. I don't know how much expenses they incurred, but still, So let's see what they said. Basically, is there consideration? Can Lampley sue on the promise? Which promise? Which promise are we talking about here? When Braithwaite said, I will pay you £100. That's the promise. I want to enforce that promise. Can I do that? That's the question. In order for you to do that, that promise has to be part of what? A simple contract. So you have to have the agreement, the intention to be legally bound, and the issue for us, consideration. So they said a contract existed. See? Agreement, intention, consideration. As the request for Lampley's service by Braithwaite and the performance, so Fluffy, performance of those services, coupled with a subsequent promise to pay, because this is pretty much like Roscola and Thomas. See, Roscola said, give me the horse, yes, here's £30, and then later on he said, oh, can you also promise me that this horse is sound? And Thomas said, yes, I promise you. This is pretty much similar, right? No? There are two promises. Here there's only one promise. And the promise came after the pardon, after the performance. Where's the difference? Here's the difference. It said the previous, this is what I call the sandwich type of cases. The previous request, what's the previous request? Braithwaite's first request was what? Help. Help, right? He wants help. Find me a pardon. Okay. That's the previous request. And the subsequent promise. What is the promise? I'll pay £100. Were treated as part of the same transaction. So that's what we call the sandwich. Braithwaite asked for help. Braithwaite promised to pay £100. What happened in between? The performance. So we're saying that performance is connected to both of these. Subsequent £100 promise and the previous request for help. So when the request was made, this is my argument about the reasonable person. When the request was made, there was an implied promise to pay something. Because as a reasonable person, why would you go incur all of this expense if you don't have this implied promise that you compensate me for my expenses? Otherwise, why would I go and do it? Unless I'm your friend or I'm your, my relative or something. Okay? So that's the implied promise. So do you see how we solved the problem? We inferred that there was an implied promise which sort of was the incentive for Lampley to go and incur the expenses in getting the pardon. And said the subsequent promise, £100, okay, quantified the amount that would be paid. So the difference is that you knew that you're going to be paid something, and because of that you went and got the pardon for this person, but you didn't know how much they're going to pay you. The £100 was simply a clarification that this is how much I'm going to pay you. It wasn't something out of the blue that, oh, I never thought about paying you before that, and now I'm just thinking about paying you because you got the pardon. It's just a matter of saying, okay, I'll pay you impliedly, and now here's exactly how much I'm going to pay you. Okay. So, case reflection. 4 requests for goods or services often don't include a discussion about payment. Okay? But do you think that both parties assume that the goods or services will ultimately be paid for and that the request and the subsequent promise to pay are able to be linked together? Okay? So just to emphasize the point that as a reasonable person, when someone asks you for something, it's not for free. It doesn't matter whether you are the actual expert or you're going to go and find an expert. What's important is that I'm going to get you that service. And I expect reasonably that you are going to be compensating me. Right? Now, there are things here that are called risk management alerts. I don't go through them, but probably these are the take-home messages for you as business students. So just make sure that you go through them, okay? So this one, for example, says, remember that as a general rule, if this was my textbook, you'd find that every time they say as a general rule, I highlight this in red. Because that's what I want to have in my notes, for example. Because that's the law. As a promise or a promise made after a contract has been concluded is not enforceable, this is past consideration, unless it can be shown that the subsequent promise can be linked to the original transaction, like the pardon case. Okay? Let's go to Dunlop. 265. This one. So this is a bit better, 1915 now. So it says, Dunlop, a tire manufacturer, sold its tires to dealers, okay, who undertook to allow a 10% discount from the plaintiff's list. The plaintiff is Dunlop, the manufacturer, when reselling the tires to retailers. Okay? So there's a discount as you sell from the manufacturer to retailer to another retailer and so on. The dealers agreed that when they sold tires to any retailer, they would obtain from it a written undertaking, so promise, that the retailer would observe plaintiff's prices. So you can't undercut the manufacturer and sell way too low. Okay? So there's a promise, you can't do that. And who took this promise? Not the manufacturer, not Dunlop, but the dealers, i.e. the retailers. All right. Now we have this diagram, look at it. Now there you have Dew & Co., one of the dealers, entered into contact with Dunlop. So the first thing was the manufacturer, and the manufacturer is going to sell to one of the retailers. These are the promises, do you see them? So I promise to give you the pen or the tires, whatever it is, and in exchange you'll give me money, but what is that? Undertaking. What undertaking? Undertaking that you are not going to undersell. You are not going to undersell my tires. The undertaking we just talked about, which is this undertaking right here, a written undertaking that the retailer would observe the plaintiff's prices. That's what we're talking about here. That's the undertaking. Okay. So these guys sold tires to Selfridge, which is another retailer, which also undertook to abide by Dunlop's requirements. So again, we have another contract, simple contract, an exchange of promises. I give you tires, you give me the money, and the undertaking. So what's the problem? Selfridge sold these tires below the recommended price. So they gave a promise, this promise, and they broke it. So when they sold to the customer, they sold under the manufacturer recommended price. So the manufacturer brought an action against this last retailer, Selfridge, okay, for something called breach of contract. That's what we call the cause of action. Which contract did they breach? Okay. Which contract did they breach, do you think? Yes?
They breached the overriding one between Dunlop and Selfridge and Co. But the thing is, what I find a little weird is if they sort of have like about 10% below or something like that there, then it means that Dew & Co. and Selfridge would have to be sort of, you know, paying the same amount. Therefore, they wouldn't make money off each other. So it's not the purpose of Dew & Co. and Selfridge & Co. creating a contract.
Again, keep it super simple. Okay, let's ask the first question is, they're saying that Dunlop wants to bring this cause of action for breach of contract, breach of the undertaking, right? Which undertaking are they talking about? Yeah, okay, which undertaking they're talking about? This undertaking? These people broke this undertaking? No. These people broke the undertaking? This undertaking? Yes? And this, no, sorry, no. Which undertaking was it? They broke this undertaking. Who broke this undertaking? Selfridge. It's okay, one step at a time. So someone is saying, we broke this undertaking that we gave to the manufacturer. Who gave this to the manufacturer? Dunlop, Dew. But who broke the undertaking? It wasn't Dew, it was Selfridge. So they broke their undertaking to Dew. What business then got Dunlop come in and say, you broke the undertaking? Which undertaking did they break? Selfridge never gave an undertaking to the manufacturer. They gave an undertaking to Dew. So if there is actually a breach of contract, it's this contract between Selfridge and Dew, not between Dunlop and Dew. Yes? This actually case says that the consideration must flow from the promisee. Okay? So, if we say that the consideration here is the undertaking, you see, Dunlop is going to give you the tires, and your consideration for it is money plus this undertaking. So all of this is your consideration. And you are the promisee. He's promising you to give you the tires, and you're promising to abide by this undertaking. So if you go up a little bit more, or if you go on page 264, this is a case that says consideration must move from the promisee. Let's continue. The decision. So the question was, could Dunlop then enforce an agreement to which it was not a party? So this is a principle we call the privity of contract. We'll talk about it later, we'll talk about validity. Okay? But as you can see, we're saying that the contract that was broken or breached was based on this undertaking. And this is only between Selfridge and Dew. This guy has nothing to do with it. So how come they want now to come and sue on breach of contract? Okay? So only the parties to the contract could sue on the contract. That's the decision. Dunlop had not provided any consideration for, so this is the key point that we want to talk about. They did not provide any consideration for Selfridge's promise. Okay? This is a promisor. What is his promise? The undertaking. Who's the promisee? Dew. What is his consideration? I will give you the tires. Is there any promise flowing from this promisor to this promisee? No. So there can be no consideration from this promisee flowing to this promisor. So this promise was not bought by Dunlop, it was bought by Dew. Because they gave this consideration, these guys didn't give any consideration. Even though they have given the tires to Dew, who eventually gave it to Selfridge. Okay? So the point is again, consideration is one of the rules that we talked about. Consideration must move from the promisee. In this case, the promisee is Dew on the undertaking, not Dunlop. So they also talk here about something called privity rule or privity principle. We'll talk about that in much more detail some other time. Okay? That's okay. Let's continue now with 1967. Cowles, I think, and Bagot. High Court of Australia. This is husband and wife. Okay? So it says the husband granted mining rights to company. He has a land. Company wants to mine. He said, yes, here is rights, go ahead and mine. And in exchange, in return, a royalty was to be paid to whom? To him and his wife. Who owns the land? The husband. Who's getting the money, the royalty? The husband and the wife. The wife provided no consideration. You see that? Why do we say the wife provided no consideration? The royalty is coming out. So what are the promises that are exchanged? I will give you the rights to mine. That's my promise. Your consideration is the royalties. I'm the husband. I'm the owner of this land. I will give you I'm the only one who can give you the right to mine because I'm the owner. That's my promise. Your consideration is the royalties. Where's the problem? The royalties are not just coming to me, but to also my wife. If this was a deed, a formal contract, we don't have to worry about consideration. But because it's a simple contract, now we have to ask, why is the wife getting anything? The wife is being promised royalties. What did she give? What did she buy that promise with? That's the problem here. So let's see. Was the agreement between the company and the husband alone? So in which case, the royalty payments would cease on the husband's death. Okay? Because the contract is between me and you. You die, and that's the end of our contract. The contract is discharged, we say. I will talk about discharge at the very end. Or, the other option, was the wife a party to the contract, and as we call her, a joint promisee. So my promise to give the royalty was not to one person, it was given to both of them as joint promisee. Not separate promisees, two promisees, one promisee, joint. Joint promisee. So if one of them dies, the other is still standing. Decision. While consideration must move from the promisee, that's the Dunlop case just before, the promisee here being the wife, where the promise is made to promisees jointly, consideration need only move from one of them for the promise to be enforceable. That's our rule. That's the law. Okay? So if you make the promise to two people, but you're making it to them as a joint promisee, not promisees, one, if one of them dies, it doesn't matter. And not just that, it doesn't matter whether they both provided consideration or not. You only need consideration from that joint promisee. It doesn't matter whether it comes from the husband or it comes from the wife. Yes? All right. Let's continue with page 266. Chapel. This is the Nestle case and the wrappers. 1960. It says to promote the sale of its chocolate bars, let's get rid of these a bit. Nestle offered a record, like a CD, okay, for 1 shilling and 6 pence plus. I will give you that CD or record, but you have to pay me that money, and not only the money, 3 wrappers, okay, from 6-penny bars of chocolate. So you have to buy these bars of chocolate, eat those bars of chocolate, whatever you want to do with them, and then take the wrappers and take 3 of those wrappers, 3 wrappers, plus this 1 shilling and 6 pence, and give that all to me, and I will give you this record. So do you see the promises? I promise you the record. In exchange, your consideration, the price you're going to buy this record with, is going to be this money plus the wrappers. So far, so good? No problem. What's the problem? Tax, of course. Let's see. Or royalties, even. Chappell & Co., these are the guys that are brought proceedings for infringement of copyright, and Nestle offered to pay a statutory royalty based on the 1 shilling and 6 pence. So the IP belongs to these people, the record, and they said you can't go and sell this because this belongs to us. So Nestle said, look, I will give you the price, which is the 1 shilling and 6 pence. But they didn't include this 3 wrappers. 3 wrappers, it's just something that people throw away. Here's why. The issue, while the wrappers themselves were of no value, okay, we're here, as they were thrown away, should they be included as part of the basis for determining the royalty to be paid during the purchase price of a bar as a benchmark. If a person wanted a record, they had to buy 3 6-penny bars of chocolate. So they said the wrappers form part of the consideration because the 1 shilling and 6 pence alone was not enough to obtain a record. Nestle had to pay a royalty based also on these 3 shillings. So this just simply states that the court is reluctant to become involved in the question of adequacy of value. So the consideration has to have value, it doesn't have to have adequate value. As long as there's some value, the court will be satisfied. But whether that's something of value, okay, that is the wrappers, were part of the consideration for the records or a condition that had to be satisfied before the customer could get the record is not clear, as there were a range of issues expressed on this point. So when you go and read the case, actually, you'll find that some people said actually it's not part of the consideration, it has to be part of the condition for you to be able to get the record. So it doesn't actually form, so like a condition precedent. Before you get this contract and the promises between us, you have to buy those 3 chocolate bars. A similar problem, if you have Khalil, remember Khalil? The woman that got sick after buying the smoke bowl? It says, where in Khalil's case, the smoke bowl, okay, was part of the consideration. But, sorry, where Khalil's use of the smoke bowl as directed was part of the consideration, but a condition for getting the money was that she also had to get the flu. Okay? So there, before you actually get this exchange of promises, there's a condition precedent, which means that you have to get the flu and you have used this bowl as directed, and then you contract the flu, and that condition kicks in those promises where you can actually claim compensation. All right, let's keep going. Poppy and Poppy. This is page 267. The wife had left her husband because of his domestic violence. Okay. To encourage her to return home, note this is 1959. The husband promised the wife verbally that he would put the matrimonial home in their joint names. So he said, look, if you come back to me, I will change the ownership of this home so that we become joint owners. So she returned. Okay. After 4 weeks, she left again, because as you would imagine, there was another dispute. This is 1959, folks. Under the legislation at the time, she was under statutory duty. So there was an act that said, as a wife, she has to return and live with her husband. 1959. She returned, but back then, she was under a legal duty to do so. So do you know where I'm going with this? Consideration. Was this a separate consideration, returning? So do you understand what happened here? There was a promise saying, I will give you the house, or I will make you a joint owner. That's my promise. Your consideration is come back home. But I'm telling you, coming back home was already under statutory duty. You have to come back home. Even if I don't promise you, under this law, back in 1959, you have to come back home. So what is your consideration? That's the question. So the issue, was she entitled to enforce her husband's promise? The husband argued that she was already under a duty to return, so she had not suffered any detriment in exchange for his promise, i.e. she did not pay anything for it, she did not buy his promise. What did the court say? There was good consideration. How? Even though the claim failed on other grounds, they said what? Mrs. Poppy had a right of something called constructive desertion. So they said even though she has this duty she still has the right of a constructive desertion under the legislation, and so in returning she went beyond her statutory duty. So they said by returning she was forfeiting something called constructive desertion because of the domestic violence. So what she did by returning was over and above what she should do under the act in terms of returning and living with her husband. And that's all you need to establish consideration. She suffered the detriment. That's what they're saying. She suffered the detriment. You know that when you pay a price, when you give me money, that's some sort of a detriment, right? You give me money for what? You have to have something of benefit. So she wanted the benefit of the house, but the detriment was I have to go and live with this person who has already abused me. And that is something you don't have to do even back in 1959 because of this constructive desertion. They said Mrs. Poppy had returned to the family home against the background of domestic violence, and thus was placing herself in a position which she could not have been compelled to occupy by law, even in 1959. So she was suffering a detriment while Mr. Poppy gained a practical benefit, of course, of her being with him and living with him. Okay. So once again, happy to keep going? Are we still here? Okay. Still America. 1809. We go back to 1809. UK. A number of seamen signed on in London for a voyage to the Baltic and back. There was a voyage to the Baltic and back. During the course of the voyage, 2 men of them deserted ship. During the voyage to the Baltic and back, 2 of these seamen deserted the ship. The captain tried to find a replacement. He couldn't. What did he do? So he said, look, the remaining seamen, I promise you the wages of these 2 people who deserted. So I will take their wages and distribute them among you who are still left on the ship, if they would walk the ship safely back to London. So that's his promise. This was agreed to, and the return journey was successfully completed, but the owner then, of course, reneged and refused to pay. The question is, was there any consideration? The captain promised that he would pay those wages over and above the wages that he would get. Okay. Those seamen who still are on the ship, what was their consideration? What did they pay for this promise? So, yes? So, was it enforceable? I.e., was there any good consideration? What did the court say? No. Why? The sailors had undertaken to do all they could under the normal conditions of the voyage to bring the ship safely to port. The desertion of the 2 seamen did not extend the remaining seamen's existing contractual duty, as the court considered there was no increase in risk to their lives. What they're saying here, remember, consideration is something like a detriment, like the woman who went back to home under this condition of domestic violence. Here, they're saying 2 men deserting is not going to increase the risk of this voyage being successful. 2 men, we don't know how many seamen are on the ship, of course, but they're saying 2 was not enough. The risk is still the same. So why should he give you more money? What did you do extra to actually earn those other wages, the 2 wages that were promised? Yes? Keep that thoughts in mind, and let's look at the other case. Hartley and Thompson, 1871. Look, this is 1809. But look, nearly half, now we have proportion, nearly half the crew deserted the ship in Port Phillip in 1852. Half deserted. Okay? To encourage the remaining 19 sailors, so we know exactly how many sailors deserted, to complete the voyage back to Liverpool, again the captain promised them extra wages, just like we saw before. But because the ship was so undermanned, it was seaworthy. Does that say something to you? Yes, it means that if I accept this offer, the promise to pay me extra wages, I have to do something over and above what I have to do on a normal voyage, where there's no increase in risk. You're telling me that this is unseaworthy. Detriment. Thank you. Someone said there's now an increase in risk. There's a detriment. So what do you think? Is that a good consideration? I think so. So what did the court say? It said sailing the ship back to London in an unseaworthy condition was more than the original contract required. That's all we want. The promise of extra wages was supported by good consideration. Williams, the Roffey brothers. Roffey brothers had entered into contract to refurbish a block of flats. The plaintiff, Williams, entered into a subcontract with these subcontractors, the defendants, to perform certain carpentry work. And it was for a fixed sum. But these subcontractors experienced financial difficulties. Because what did they do? They underquoted the job. So what did they do here? They want to make sure that they win the subcontract. So how do you do that? So they went in with a tender with a very low price. So I will do this carpentry for you for much lower than anyone else. And he said, that's great. So I will hire you. Yeah. And then they hired them, but now they realized that they were underquoting to get the contract, but they can't actually perform the work with such low pay. Okay? When he told the defendant he would not be able to fulfill his obligations, the defendant, that's Williams, offered to pay him extra. Okay? Offered to pay him extra for each flat completed so that it would have the project finished on time. Why? To avoid paying a penalty for late completion. Okay? You see the detriment? He's saying, look, and substantially completed an additional 8 flats, but when the defendant, so the defendant is the Roffey brothers, not Williams, when the defendant failed to pay any of the additional money, Williams stopped work and claimed the balance owing under the original contract, plus the additional payment that was promised. Roffey counterclaimed for breach of contract. He said, you're breaching the contract that we agreed on originally, which is what? To do this subcontract at that price. He doesn't want to fulfill the promise of paying extra. So, was the promise of an additional payment enforceable? So, how to analyze that? You have to ask, was there consideration? Or was the plaintiff under an existing legal duty? Remember the legal duty we talked about, the wife and the domestic violence? Similar. Or the ships. Is that their duty, or is it something that they have to do more? The defendant's promise was enforceable, they said. Why? There was commercial benefit. Remember the detriment? For the defendant in having the work completed on time, so you don't have to pay the penalty. Not having to spend money on time finding another carpenter, and not having to pay the penalty, and this all amounted to sufficient consideration. So they said you have to pay him the extra money, because by that promise, Williams, bought that promise from you by saving you the detriment of the time that it takes to find someone else, and of course, the penalty that you would have to take. Okay? Technically, however, so this is the problem with law, or legal theory, technically there is no consideration. Why? The practical benefits to the parties were what constituted the consideration in this case, and it illustrates how the law on this topic has developed over the years. Today, the courts are more likely to find that a promise made by one party to a contract to make an additional payment to another party in addition to that which they were already entitled to under the contract may constitute consideration if it can be established that the party promised an additional sum, secured for themselves a benefit, and avoided a detriment. So they're telling you that's how we now came to understand why this case is correct. It's correct because of this idea of if you can establish that my consideration to you is that I'm going to save you some detriment, so you don't have to pay a penalty, or any other kind of benefit that you're going to get, that's my consideration. All right. Let's do a few more, and then we'll stop for 10 minutes, and then we'll go for our tutorial. Scottson and Pegg, 1861. The plaintiff had entered into contract with a third party, again, to deliver a cargo of coal to him or to his order. The third party sold the coal to the defendant and told the plaintiff, in accordance with the contract, to deliver it to the defendant. So there's a third party, and now we're arranging for this coal to go to the defendant. The defendant then made an arrangement with the plaintiff that in consideration of the plaintiff's delivery, or delivering the coal to them at their request, they promised that they would unload it at a specified rate. Okay. The defendant subsequently broke their promise and the plaintiff sued for breach of contract. Same idea. Could the defendant successfully argue lack of consideration? Decision, delivery of the coal was a benefit to Pegg, and so that is enough consideration to support their promise, so they have to pay. Okay. Now let's go to this case, and there's something behind this case called the Fox and Beer principle. And just like we said with the poster rule, you could actually stipulate for it to be not applicable to your contract. Okay? You can exclude it. Let's look at it first. 1884. This is about payment of debt. Beer had obtained a court judgment against Fox where he agreed to settle a debt by the payment of £500 immediately and the balance by installments. So there's debt between these parties. Okay, they ended up going to court, and the judgment was that you have to pay £500 immediately and then the balance by installments. What's the problem? Beer agreed not to take any further action on the judgment, so he's going to wait for that installment. Okay. All judgments bear interest rather from the date of judgment. So you don't have to only pay the installments on the original debt, but you have also to pay interest. Fox, after Fox had paid the final installment, Beer sued for interest. So what's happening here is that they agreed on a certain sum, saying that you pay me immediately £500, and he did, and the balance by installments, which he did. But then Beer, because he's also entitled to interest, said, yeah, you paid me all of that, but usually these judgments come with interest. So I also want the interest now. What did Beer say? He said, you agreed that that's how much I'm going to pay you, and that's it. So what's the problem here? So you can see the promise, right? The promise was, what is the promise? Fox promised to pay £500 plus these installments in consideration of what? Beer said what? I will not go on and take any further action. So that's the end of the matter. I will settle the debt with this payment. £500 plus the installments. Yes? But just like the horse, remember the sound horse? After that's finished, now Beer wants to get also the interest. Okay? So what did they say? They said Beer was entitled to recover. Okay? Why? Because the payment of the smaller sum, i.e. the debt and the costs, the installments, was not consideration for the promise to take any further action on the judgment. So, again, there's a promise from Fox to Beer saying, I will pay you £500 plus the installments. Beer said, okay, I will not take any further action. But then they went to court again, and the court said, actually, that promise not to take any further action is not supported, because what you paid is less than the original amount. Where is the difference? Interest. So they said, Beer would still be entitled to that interest. The key point here, you can actually put something in your contract, stipulate that that doesn't work. So the comment, difficulty with the decision was that it ignored commercial reality. It struck down what were essentially fair and reasonable commercial transactions. So if we agree to do this, the court shouldn't come and do this. Okay? So this left the promisee with only limited resources until we were able to develop the law with a new legal theory, and that legal theory is called promissory estoppel. We're going to look at promissory estoppel in just a minute. Just remember that if there's a third party involved, like in this case, this is also settlement of a debt, but now it's not the person himself who's going to pay, it's his father. And because his father is involved, the court said that's enough. You can't go and do the same thing to a third party. That would be unconscionable. All right. Let's move on then, straightforward to the last two cases on pages 274 and 275, and we're going to talk about estoppel as an exception to this idea that for a simple contract you have to have consideration. Okay? So we're looking at something historical, which is the one from the United Kingdom, 3 trees, and then we're going to look at Walton's. So let's look at this one first. Central London Property Trust and High Trees House Limited, 1947. It says in 1937, the plaintiff leased a block of flats to the defendant for £2,500 per annum on a 99-year lease made under seal. What does that tell you, made under seal? It is a formal contract. Does it require consideration? No. Thank you. So, why are we talking about consideration here? Let's see. We're talking about promissory estoppel, not consideration. In 1940, at the height of the Battle of Britain, and in the early days of the German bomber blitz on London, many of the flats became vacant. Okay. And the defendant was unable to pay the annual rental. So, after discussions with the parties, or between the parties, the plaintiff agreed to reduce the rent from $2,500 to $1,250, from $2,500 to $1,250, by half. You see why? Because it's the commercial reality. People are not actually renting. So the agreement, however, did not stipulate the period for which the reduced rent was to be paid. They said we're going to agree on a new rent, so you can see the variation of contract here, but we don't know for how long. They didn't say anything about that. Okay. By mid-1947, so we're going with World War II, the plaintiff was in receivership. Okay? So there's a receiver because they are bankrupt, so someone will have to come in and settle for the creditors. So he's trying to find money. The receiver wants to find money. So they discovered during an inspection of the plaintiff's accounting books that even though the war in Europe was over, the defendant was still only paying $1,250, and not the original $2,500 due under the lease. So the defendant argued that the variation executed in 1940 extended for the full 99-year term of the lease. The receiver claimed that the variation was supported by consideration and was therefore not valid. So the receiver claimed that this $1,250 is not valid because you didn't pay anything for this promise. Why should I give you this benefit of half price? What did you give me in consideration? And that the defendant then owed the full amount, being the difference between what was paid and what should have been paid over the war years from 1940 to 1945. Let's just look at this as well. So eventually the receiver subsequently decided to test the legal position of the parties with regard to the rent of the last 2 quarters. So they didn't go for the full amount, they just wanted to test. Can we get some of this money? Remember, this guy is wanting to get money, not wanting to spend money on litigation. So they wanted to test. And the best thing to test was the last 2 quarters, because the war is over. Claiming 625, which was the difference between the rent for the 2 quarters. The issue, could the defendant argue that notwithstanding the contract between them, he had relied on the plaintiff's promise to reduce the rent during the war years? If the plaintiff was now allowed to return to the original agreement, the 2,500, and be allowed to enforce it for the war years, wouldn't this be unconscionable? Okay. So, what did we say previously? This is very different from all that we said previously. We said previously, I promise you to give you half price. You have to buy that promise from me through consideration. And the question is, what was the consideration here? Well, there was none. But this was a deed. This was a deed contract. Why would you need consideration here? Because it's a variation. So they're saying, this is like a new contract. You're telling me half price. What am I going to buy that from you with? They said you don't have to. Why? Because of fairness. If we insist that there has to be consideration, the outcome, the legal outcome, is not fair. Because it was something that you relied upon, knowing, again, the reasonable person, you're not going to be asked later on after the war to go back and pay the difference. Do you see that? I would have just simply canceled the contract because I don't have people taking the flats and moved on exactly like them, you know. If no one is taking flats from me, I will just cancel and move on. You said, no, stay, I'll give you half price. Okay, that's a benefit for me. But it doesn't mean that a reasonable person would come back and say, after the war, you come back and say, pay the difference. Yes?
So, are you saying that it was okay for him to sort of be a bit sort of flexible with the law purely because there was the war there and it would have been unfair to charge people the same amounts even during the war period when the economy was doing right? So,
you are business students. We're talking always about business efficacy.
Well, I'm not a business student, but I would assume that, like...
So what are you studying?
Marketing.
Okay, so it's still business, right? Marketing is part of business, really. So what we are saying still is this business efficacy. The idea is that you are doing, why do you think they gave them half price? Because half price is better than zero price. The other alternative, the other option is that this person is going to say, I can't pay you, I have to cancel and move on. You said, it's okay. Take half price because you know when the war is going to end. And let's say it goes. They took that risk. That was a detriment to them in that sense. But we're not going to talk about it as a consideration. We're going to still say there's no consideration in this case. In fact, you don't need consideration because the original deed didn't require consideration. But there was this variation. And the issue of the variation, can you now come back and say you have to pay all the money that was owing from 1940? Of course, that's not what they're asking for. They're going only after the war, only for 2 quarters, just to see. Okay? What did the court say? So the plaintiff was entitled to recover the last 2 quarters of rental. That's what they said. Denning Gay, who's one of the probably most famous justices in the 20th century in the UK. But this is arbiter. Remember arbiter? He's not actually saying this is the ratio. He's saying you have to pay them. But he said arbiter on different facts. The defendant did not have to pay the areas from the time of the agreed deduction in 1940 up to the time when the flats were again fully let in 1945. So as long as that risk of people know that there's a war, so the flats are vacant, people don't want to use them, you don't have to pay the areas. But from the time that the flats went back to normal, so people now, the war is finished, people are going back, so you have now, because you have full capacity, you have to go back and pay the 2,500. Correct.
Because the demand was so much lower that he was legally allowed to increase this.
So all of this is back to business efficacy. If there's no demand, so I'm better off if you can give me half price. And as long as there's no demand, you pay me half price. Once the demand is back to normal, it's reasonable for me to expect that we go back and you pay me the 2,500 again. All right. There's a similar. This is what we call using estoppel as a shield. Okay. So it's being used as a shield by the innocent person. So the innocent person is saying, I shouldn't pay you for that areas because you promised me, even though I did not buy your consideration. In Walters, that's going to be used as a sword. I'll leave that for you to look at. And we'll have a break and come back at 3 o'clock. I will start on a few, just 2 or 3 questions. All right, see you soon. So come back 5 to 3, please.